What's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. This is something that is uh, very big news when it comes to helping you, helping other clients. This is very big. This is a case that came out of the United States District Court, Southern District of New York, and it was Unsolved Inc. and Reverend John Udo Okan versus, and it says Letitia James, but it's really Attorney General's office. And what they were suing for was the right to give individuals, which was mainly people who don't have a lot of money, the poor or even middle class that are living paycheck to paycheck, that cannot afford to pay a lawyer, $100 an hour, $150 an hour, $200 an hour to talk to them and represent them in cases against debt collectors. And this group here, Upsolve Inc., what they did is they were a nonprofit, or they are a nonprofit organization, and they would give people advice and telling people, hey, this is what you could do if you have debt collectors suing you. This is your rights. And what happened was, I guess the debt collectors maybe got the attorney general's office alerted to it, and they tried to say that they were giving individuals legal advice, and they couldn't give legal advice because they're not quote unquote lawyers. And so this case has been working its way down the pike, and a judge finally gave a ruling. And this is the thing that I believe is huge with this, because this is not just with New York. This is something that is about to sweep all 50 states of the United States. We're in this do-it-yourself economy. We're in this advice economy, and yes, some advice may not be good, some advice may be bad. But what one of the things that is in common is that you have people who can give you good advice, and they don't charge the same as what other people would charge. And there are people that may not be lawyers that specialize in certain things, and lawyers don't really like getting involved with these debt collector cases because, number one, they need to get paid, and really the only way that they're going to do something is if they find a violation. But if you look at what you got to do to find a violation, you're talking about recording, you're talking about all types of stuff to prove your case, and then you're talking about $1,000, and then you're talking about the fees for the attorney to do it. And so that's why you don't find too many attorneys working in the debt collection. They're working on the other side as the plaintiff, helping the plaintiff. They're not working on the side as for representing. So what this order was, put this opinion in order, was saying that they can give legal advice, and it's really based off of they're giving good advice. It's just that they're not lawyers. And they said that really the only reason why people that are defendants that get advice from lawyers, it was just the way that the wording was. Let me find that little section here. It says that the background on it. Let's see here. There was something about the way that the context was written in the law that stated that you had to be an attorney to give someone advice, but it does not work that way for the plaintiff, because they say that the plaintiff can actually get advice because they consider what they're doing as free speech. Here it is. Plaintiffs have crafted a program that would try. Okay, this is something that they did. Plaintiffs have crafted a program that would train non-lawyers to give legal advice to low-income New Yorkers who face debt collection action. Specifically, plaintiffs want to help those New Yorkers fill out check boxes, one-page answers, forms by the state, in hopes that more people will avoid defaulting outright in such actions. And this is, the type of work that we help people with. We're just like, this is what you need to do. This is what the right thing that you would say when someone asks you this question. It's not like you're really giving them advice. You're just saying this is what you do. But the way that the law is written, you can't even tell a person, hey, check this box. They would consider that being legal advice. Well, in New York, they've taken that away, and now they're able to give them, to like point them in the right direction. So the plaintiff proposal faces one problem that giving legal advice as non-lawyers, the activity would constitute an other authorized practice of law, UPL, under the New York statute. The risk being sued by the defendant in this New York case, the New York State Attorney General's office. Thus, plaintiff seeks an injunction that prevents the Attorney General from enforcing the UPL rule against them. And this is going to be big all across the country because these people don't know, and they're, always claiming to be on the side of people who don't have a lot of money. But then the only way that a person that can get represented is if they're able to pay to have, attorneys represent them. Not to say that attorneys are bad. It's just that people can't afford to do this stuff. And really, a lot of this stuff is very simple if they just knew what to do and what to say, and then the judge would be able to hash out everything. But what's happening is that a lot of people are just defaulting because they're like, I don't know what to say. I'm afraid. I don't know where to begin. Anything in the way that the law was written, if you just you know uh, gave someone some of that information, they would try to say that you're giving them legal advice when you're really just saying, "Hey, this is what I would do if I was in that situation, and this is what you could do." We see this all over YouTube. We see this all over everywhere, where people are just saying, "Hey, this is my experience, and this is what you should do." Well, the way that the law was written in New York is that you can't technically do that, but if a person says that they're going to be pro se, then they would be okay. This kind of some of this also kind of stems from where debt collectors are just saying that an individual is winning. Too many of these people are winning. How are they getting the information to fight back against us? So here's a little bit of background about it. It says in New York, the debt collector actions in New York State, debt collector actions are extremely common in New York. By one estimate, they comprise approximately a quarter of all lawsuits in the state. One quarter. So if you got a million lawsuits in the state, that means that you have 250,000 debt collector collection lawsuits. And it says that the default rate ranges from 70 to up to 90%. So that means that because people don't know their rights, because people are afraid, because people don't have the money, they can't miss work, they don't get paid when they miss work, they work low wage jobs, they are not going to be able to go to court. So they just have a default judgment, and then they're just taking the money right out of their bank account. So everyone is saying that this is going to be something that's going to be moving through the pipeline for all states because they're going to want to be able to allow people to get help. I mean, we're in this do-it-yourself economy, and there's going to be opportunities for individuals to be able to get information and to be able to take their, well, you can already do it. It's just that there, some debt collectors were trying to put a stop to people even being able to do that. So they had kind of, I guess, forced uh, the New York Attorney General to try to enforce a certain law that's on the books, but it looks like they're not going to be able to enforce it. I'm going to put this on this link below so people can, if you want to read through it, the entire case, so you can see what was, everything that was going on, the challenges, and why the judge decided to make the decision. I believe that this is a good decision. This is a good decision for the people. This is going to help a lot of people be able to fight back against debt collectors. Um, as I've always stated, that when you're fighting against a debt collector, especially a third party debt collector, that they have to prove everything to be able to collect. And they usually don't have all of that documentation. A lot of the times they get very lazy because they know that when you have a default rate which it's stated right here, up to 70, up to 90% are not going to show up. They could just put a couple of things on a piece of paper and provide a couple of documents, and then they know that most people are not going to show up. And then if they do show up, are they going to ask the right questions, or are they just going to sit there and say, well, I don't know how I'm going to pay the debt, which is what a lot of people do. I made a video a long time ago, and it kind of flew over people's heads when I said, if you go into court, even if you don't have your summons, a response to the complaint, that one of the best things that you could say to the judge when they ask you about the debt is to say, I do not know about this debt. And that's gonna point back, at least if it's a judge that's gonna be open for both sides. They're gonna say to that debt collector, what are the documents that you have to prove? And you have a right to be able to have everything unredacted. You have a right to have everything to prove the dollar amount of their claim, and they're not going to be able to get that. So most of the time, the debt collector will either say that they're going to dismiss it, or they're going to ask for more time. And when they can't get it, they're going to try to have people, see if you're going to show up to the next court hearing. And if you don't show up, they're going to ask for a default judgment. If you do show up, they may just outright say that they're going to dismiss it. It's because they cannot get all of that information. And there's other things that they can't prove either, but that's like basis. Like if you got to go to court today, you watch this video and you got to go to court today, or you got to go tomorrow morning, and you don't have the time to write a response. If you just simply say that, most judges are going to ask the debt collector to produce those documents. And the documents that they produce, the court summons and a couple of statements, does not add up to a full claim of the amount that they're trying to get you to pay. So all you have to do is you just got to uh, make them prove everything. All right, I'm going to end the video here. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process, my 2-phase settlement process. We don't just send out letters. We work with the credit reporting agencies for inaccuracies, and we work with the furnishers to make sure that they had a right to come after you for the debt. If they do, we can help you with it, it- you know, guiding you on working out settlements so you can move forward. So we can, get you to where you want to be rather than just going through the long processes. But we do understand that some people don't, just like this lawsuit said, they don't have the funds, and you have to kind of, go through the process, and it might be one of those one at a time things, or where you save up money. But we'll be here to help you. That's what we do. If you don't have your credit reports and scores, please go to the website, yourorder3scores.com. Grab your TransUnion, Equifax, and Experian reports. Those are very important. You can see all of the information that debt collectors have on there. It's very important. You need to know always what's going on with your credit. If you have debt collectors coming after you, I invite you to get my 3-pack of letters. Right now, they are still free. Link is below here. Cease and desist collection activities letter, debt validation letter, and my statute of limitations letter. Thank you for your time. Make sure you subscribe to the channel. Make sure you post your comments and questions. It's Stephen A. Williams, President and founder of thecreditrepairshop.com.